Okay, thank you, Raji. हाँ,
Good morning. Sorry, good evening, guys. Can you hear me? Please just give me a heads up if you're able to hear me. मैम क्या प्रॉब्लम हुआ था इसमें?
पब्लिक कर कर आ नहीं सकते थे। पब्लिक क्या हो गया?
वही तो Hello. Good evening. Good evening, guys. Thank you so much. Good evening. Good evening. Good evening. At least wish तो कर दो. Yes. Good evening. Good evening, guys. So today what we are going to discuss is the rest of the special contracts that are left to be done. Did you revise whatever was done in the previous days? Did you revise whatever was done in the previous days? After yesterday's law paper, CA inter law paper, it feels even more little more scary also, right? It's a little more scary now. God knows what they will do with us. Good evening, Praj, good evening, Ayush. So, start करते हैं without much ado. Actually, we don't know what happened. There was some technical glitch. The go live option was not coming only. So we did, and then finally it started. That's the reason it started late. So let's start with the next part, that is contract of bailment and contract of pledge. So when we talk about bailment, what do I mean by bailment? क्या होता है bailment of the goods? What is bailment of the goods? Bailment basically, पहला तो bail and jail has basically no connection, guys. Remember that. So just because I say bail, it is in no way connected to bail and jail. So when I say bailment, what it actually means is I am transferring the possession of the goods. What am I transferring? Bailment is the delivery. So it is what I am transferring the possession. It is the delivery of the goods. Right? And when I say I'm transferring delivery, I am not talking only about custody. I am basically talking about what? Possession of the goods, right? I'm talking about what? Possession of the goods by one person to another. That means one person is giving the possession of the goods to another. For what? For a purpose. For a specific purpose. And once the purpose is accomplished, can the other party keep the goods? No, the other party must return the goods back. Or if he has used, the other party must return the goods back, or he must dispose of the goods as was asked. So let's say I tell you to deliver it to some person in Mumbai, then in that case you will not send it back to me, you will dispose it off to that person in Mumbai. So it will be delivered to that person. It will either be, once the purpose is attained, the goods will be returned back or disposed of in the manner warranted. The person who gives the goods is the bailor, and the person to whom the goods are given, right, to whom the goods are delivered, is known as the bailee. So what are the features of bailment? So first of all, in case of a bailment, there has to be two parties, obviously, and the contract of bailment may be express or implied. We already know what is express. We already know what is express. Express means what? By words. Express means what? By words. Implied means what? By law. The best example for implied is what? Finder of goods. By law, a contract is created, right? It may be express or implied. Then second is there must be delivery of some goods. Now please understand, when I say goods, what do I mean by goods? Am I talking about immovable property? No. Am I talking about movable property? Yes. So when I say goods, there must be some goods. Goods means what? Movable goods, right? I'm only talking about movable goods. And then the next one is the goods have to be delivered. Unless the delivery is done, it's not valid. So the possession, the delivery has to be done. And when I say delivery, delivery may be what? Actual or symbolic or constructive. Here we don't have anything like or constructive. If you remember, when I was doing Sale of Goods Act with you, voice is not. Now you check, is the voice better now? Is the voice better now? Actually, my throat has a severe infection. I don't know, not even infection, I guess. My voice has some problem. There is some problem with my voice basically. Now is the voice okay? Please do just let me know. Is the voice fine now? Still not clear. For the others also. Ayush, Prats, are you also having a trouble with the voice? Fine now. It's clear. So that's okay. Might be you can just re-log in. Okay? I mean, you can just um, click on the link again and join again. Okay, okay, okay. So delivery may be actual, symbolic, or constructive. What is actual? Physical goods are delivered. What is symbolic? You don't get, thank you guys, thank you. You don't get the goods, but you get symbols using which you can take the goods. What is constructive? There is no physical transfer of goods. Without any physical movement, the goods are delivered. Without any physical movement of the goods are delivered from the seller to the buyer. Now, the next one is there must be a transfer. So, coming from the delivery only, there must be a transfer of possession and not mere custody. Possession means what? The right to access the goods. The right to access the goods. So, when you park at some roadside, the keys are with you. They only have the custody, not possession. It's not bailment. But at valet parking, the keys are given to the other person. He has the right to access the goods at any time. That is bailment. And the last one, the bailee must return the same goods or the same goods in altered form. Same goods, obviously, I have given you this phone for using. You have to return the same goods to me. But let's say I give my a fabric to the tailor to stitch it into a shirt. He cannot give me the same goods, but he will give me the same fabric in altered form. Yeah, I gave him checks, he gave me polka dots. I'm not going to keep it, right? So the same goods in altered form. Now, when I say bailment, bailment are of two types. Okay, bailment are of two types. It may be either gratuitous or non-gratuitous. What do I mean by a gratuitous bailment? Gratuitous means out of gratitude. That means it is not for consideration, right? It is what? It is not for consideration. Not for consideration. And see, if it is not for consideration, that means both the parties cannot be benefited. So either the bailor is benefited or the bailee is benefited. So it's either for the benefit of the bailor or it is for the benefit of the bailee. It can never be for the benefit of both the parties. Then when we talk about, so it is for the benefit, exclusive benefit of the bailor or exclusive benefit of the bailee. So you have a dog, you are going out, you ask your friend to take care of your puppy. He's not getting anything in return, but you are benefited, bailor, for the benefit of the bailor. You have missed some notes, you ask your friend to lend his book to you so that you can copy. He is not getting anything in return, so it's only for the benefit of the bailee. Then it also may be non-gratuitous. Non-gratuitous means what? It is for consideration. And when I say for consideration, that means it's for the benefit, mutual benefit of both the parties. Now we are going to discuss the duties of the bailor and the duties of the bailee. Always remember, whatever are the duties of the bailor is the right of the bailee. So first of all, disclose all the faults in the goods. The first one is disclose all the faults in the goods. Now, the bailment may be gratuitous or non-gratuitous. If the bailment is a non-gratuitous bailment, I am liable for both. Okay? Now, if he fails to disclose, he shall be liable for all the damages suffered by the bailee due to such fault in the goods. Okay? I repeat again, whenever there is any fault in the goods. So, if I see it from the bailor's point, if there is any fault in the goods, the bailor must disclose the fault to the bailee. And from the bailee's point, we see If bailee suffers any damage due to the fault in the goods, the bailee can recover the damages from the bailor. So as I told you, duties of bailor is the rights of bailee. So you have to, it goes hand in hand. So what is my duty is your right. So if it is my duty to disclose the fault and I don't disclose, then in that case, whatever damages you suffer, you can claim it from me. Okay? So the first one is duty to disclose all the faults in the goods. If the goods are bailed for hire, that means it is what? Non-gratuitous. You are liable for all the faults whether he was aware of such or not. That means, if I put it in simple term, in case of non-gratuitous bailment, you are liable for all the faults whether known or unknown. Doesn't matter you know or you don't know. It's a fault, you are liable for it. On the other hand, if it is a gratuitous bailment, you are only liable for the known faults and not for the unknown faults, because I am not paying money for it, no. But when I am paying money, I don't know you know about it or not. You are liable to disclose all the faults to me. Right? Then duty to repay the necessary expenses. If the bailee incurs any expenses over the goods, see, the whole concept is, let's say I hire a car. So the ordinary expenses, what is the ordinary expenses? The fuel charges. The ordinary expenses are borne by the what? Bailee. But the extraordinary expenses are borne by the bailor. Let's say I rent a car. The fuel charges will be borne by me. But let's say the car breaks down. Then those charges will be borne by who will bear it? Bailor. So the ordinary charges are borne by the bailee, but the extraordinary charges are borne by the bailor. Again, but if it is a gratuitous bailment, okay? So I told you ordinary expenses are borne by the bailee or extraordinary expenses are borne by the bailor. But if it is a gratuitous bailment which is for the benefit of the bailor, whether it is extraordinary or whether it is extraordinary, both expenses are borne by the bailor. Let's say you give your puppy to your friend to take care for you. If let's say your puppy falls ill, right, it is extraordinary expense you will bear. Obviously the bailor has to bear. Ordinary expense, food, can you tell him, hey, buy pedigree, you also eat, he will also eat? No, that has to be borne also by you. So if it is a gratuitous bailment, whether it is extraordinary expense or it is ordinary expense, both has to be borne by the bailor. Otherwise, ordinary expenses bailee, extraordinary expenses bailor. I hope it's clear. Going on to the next one, duty to give back the loss suffered due to defective title of the bailor. Let's say bailor stole the goods and gave it to you and says to you, please keep my goods in your custody. The police comes, insults you. Because of that insult, whatever damage you face, can you claim it from the bailor? Yes. If the bailor's title is defective and due to this defective title, the bailee suffers any loss, the bailee can recover this loss from the bailor. As I told you, duties of the bailor is the rights of the bailee. Don't forget that. Duties of the bailor is the rights of the bailee, right? So moving forward, once the bailment is over, it is your duty to receive the goods. You cannot try and let the goods be with the bailee only. It is your duty to receive the goods. And if it is a gratuitous bailment, now see, when we talk about gratuitous bailment, no guys, gratuitous bailment, in case of gratuitous bailment, it can be terminated at any point. Right, but non-gratuitous bailment, only on the bailment getting over, it can be terminated. So you cannot terminate it at any point of time. Now, in case of a gratuitous bailment, it can be terminated at any time. Now, because of that termination, if the bailee suffers any loss, the bailor has to compensate the bailee for that loss. So see here, a gratuitous bailment can be terminated at any time by the bailor, even if the bailment was for a specified period. In such a case, the bailee suffers any loss which is more than the benefit that he derived, he can recover that loss from the bailor. Right? He can recover the loss from the bailor. Is it clear to all of you? Yes. Now coming to the duties of the bailee. Please remember, duties of the bailor is equal to rights of the bailee. Similarly, when I say duties of the bailee, it is equal to what? Rights of the bailor. So what is the first duty of the bailee? To take reasonable care of the goods. What do I mean by reasonable care of the goods? Reasonable care means that care that a man of ordinary prudence would take. That means if you are the owner of the goods, whatever care you would take for the goods, that is considered as reasonable care. I repeat again, what it means is, if let's say you are the owner of the goods, then in that case, as a man of ordinary prudence, as the owner of the goods, whatever care you will take, that is considered as reasonable care of the goods. So he must take reasonable care, a care that a man of ordinary prudence would under similar situations take. For example, you have someone gives you his jewelry, you keep it in your locker, you have taken due care. Any person, if he was given, if I am the owner, I would keep it in the locker. You have kept it in the locker, you have taken reasonable care. You leave it on the dressing table, someone steals it, are you liable? Yes, because you have not taken reasonable care. But you kept it in the locker, are you liable if someone steals? No. If he has taken reasonable care and still the goods are damaged or destroyed, the bailee is not liable. But let's say I tell you, please keep it in the bank locker, I will pay you the charges, and you keep it at the locker at your house. Guys, tell me, who will be liable? All of you should answer this. I tell you, I will pay you the money, please keep it in the bank locker. You keep it in the locker in your house. Who is liable? The jewelry is stolen. Who is liable? Bailee or bailor. Bailee is liable because he has not followed the instructions. So, see here, however, there are two cases where the bailee has taken reasonable care, of the goods, but still he shall be liable. First, when the bailor has given specific instructions and he, yes, absolutely, where the bailor has given specific instructions and he fails to follow the specific instructions, right? He does not, he has given specific instruction, he has taken reasonable care but not as per the instructions, or when after the termination he fails to return the goods. Bailment is over. When bailment is over, you must return the goods, but you fail to return the goods. So he fails to return the goods. Second, not to make unauthorized use of the goods. If I have given you any specific instructions on use, specific instructions on use, then the bailee must use the goods only as per the specified instructions. If he does so, he cannot make inconsistent use of the goods. If he does so and the bailor suffers any loss, he is liable to the bailor. If the bailor wants, he can even terminate the contract. So, if any loss or damage happens due to inconsistent or unauthorized use of the goods, he has to compensate the bailor for the loss. Then, not to mix the goods with his own goods. Now here, what are the situations that can happen? Let us say the goods are mixed with the consent of the bailor. Then in that case, the goods will proportionately belong to each of them. Let us say I have 30 kgs of goods, you have 30 kgs of goods. We share, we mix it and sell. We both will get half of the money. If let's say mine is 60, yours is 40, 6 is to 4, that is 3 is to 2 ratio. Okay? If it is mixed without the consent of the bailor, okay? If it is mixed without the consent of the bailor, then it is the bailee's duty to get the goods separated. Any charges payable in separation shall be borne by the bailee. So then if the goods can be separated, the bailee is bound to bear the expenses. If the goods cannot be separated, then he will have to pay the reasonable price of the goods. If the goods are same goods, okay, they are same goods. Let's say I gave you my sugar to keep, and this goods is mixed by accident, act of God, volcano, earthquake, tuk, 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 goods mixed, or by the fault of any third party, my servant mixed it, then in that case it will proportionately belong to each of us. Is it clear to all of you? Yes. Not to set up any adverse title over the goods. I have given you the goods for a specific purpose. Please use it for that. You go and bail it to someone. You go and pledge it to someone else. How can you do that? How can you pledge the goods? I have not given you the authority to pledge. So not to set up any. He has a right to use the goods only for the purpose of the bailment and should return it back to the bailor. If he gives the goods to any other person, he is hampering the rights of the bailor and shall be liable to the bailor for the loss. If you are giving it to someone else, you are liable to the bailor for the loss. If there is any accretion, what is accretion? Any increase to the goods. Cow gives birth to a calf. Shares, bonus shares are issued. You will return not just the goods, but you are also return the accretion to the goods. Any increase or profit, that also has to be returned, must also be returned. Okay? Then, once the bailment is over, please return the goods back. You cannot keep the goods. So, he is liable to return the goods back to the bailor. And if he fails to return the goods and anything happens to the goods, he has to pay the damages. Right? So, this comes here. Again, if he has taken reasonable care but fails to return the goods within the time period, he is liable to compensate the bailor. Right? We are done with this. Moving on to the rights of the bailor. Rights of the bailor. We have already done duties of the bailee, rights of the bailor, but a few more rights. Sabse pehla, can he sue the bailee to enforce the rights? Yes. He can file a case against the bailee to enforce the rights. If the bailee has made any unauthorized use of the goods, I told you please don't drive my car on hilly areas, only flat lands. You go on hilly area, car broke down. Can I recover that loss also from the bailee? Yes. Apart from that, can I also cancel the contract? Yes. In case of unauthorized use of the goods, I will not only claim damages, I will also cancel the contract. A gratuitous bailment can be terminated at any point. If it is a gratuitous bailment, you can terminate it at any given point of time. And compensation from wrongdoer, we will do it just in a while. So, bailor can enforce by a suit all the liabilities and duties of the bailee. If the bailee makes unauthorized use of the goods, he can claim the damages. He can even cancel the contract if the bailee makes inconsistent use of the goods. In case of a gratuitous bailment, it can be terminated at any point of time. He can demand the return whenever he pleases. But yes, he is liable to compensate for the loss. And compensation from wrongdoer, will do it in a while. Okay? Even for a 2 marker, you have to write the 3 paragraph. That's the format. So generally what happens in that case, it's better, you just try and finish it off in 2 paragraphs. The first few answers, make sure you write all the paragraphs, please. Make sure you write all the paragraphs. Because first few answers is the impression part. The examiner will be impressed by what you have written. So can we go forward? Yes. Rights of the bailee. We have already done duties of the bailor is the rights of the bailee. Apart from that, a few more rights. Sabse pehla, delivery of goods to one of the several joint bailors. So let's say A, B, C together run a car renting company. D took their car. D gave it to C. The moment he handed it over to one of the joint bailors, his obligation is over. Then he may deliver the goods to any one of the joint owner and without the consent, and his obligation is done. A has given his goods to B, but A says to B, please give it to C. C has no rights, but B gives it to C. Is he done with the delivery? Yes, because he's doing it as per A's instruction. If the bailor has no title to the goods, but the bailee in good faith delivers the goods to the bailor as per the instructions, he is not liable to the owner for such delivery. That means he is doing it as per the instructions. A told me to deliver the goods to C. I did it. Khatam. I am done. If someone has no rights over the goods but he is coming and asking you for the goods, can you go to the court to stop him from taking the delivery? Yes. So if any person other than the bailor claims the goods from the bailee, he may apply to the court to stop the delivery of the goods. Rights of action against third party. So this is basically what we were doing here. A gave his car to B. Car was kept in B's garage. C was playing cricket. He hit the car glasses broke off. Okay. A gave his car to B. Actually, Soumya, I have not been keeping well since the past 1 week and not getting breaks because of the classes and hectic schedule. So that's the reason. Actually, I'm very tired. I'm not keeping well also. But thank you so much for asking and noticing. I'll explain. I'll come back to it later. So A gave his car to B for bailment, and it was kept in B's garage. And C comes and C was playing cricket. He hits the car breaks down. Who has the possession of the car? B. Who is the owner of the car? A. Even though A has no possession of the car now, but he is the owner, can he go and claim the damages from C? Yes. Yes. On the other hand, B is not the owner, but the goods are with him. Can he also claim damages from C? Yes. So see here, if a third party wrongfully deprives the bailee of the possession or use of the goods or damages or destroys the goods, the bailor or bailee may bring a suit against the third party. C has damaged the goods. So both bailor and bailee have a right of action against C. Right of against action against third parties from the bailee's point. If a third party wrongfully, okay, he has a right. He bole to who is he? Thank you so much, Soumya. Here he means what? He means bailee. Has a right to bring an action against that party. Even the bailor can bring an action, we already saw. So that means A also has a right. Both of them cannot recover separately. But what the act is trying to say is any one of them can recover it. Is it clear? Point number 2, delivery of goods to bailor without title. A gave the goods to B and tells B to deliver to C. B delivers it to C. Since the delivery of goods to C was made as per A's instruction, even though C is not the owner, can we say B's obligation to deliver is over? Yes. Delivery of the goods to a person without title, like delivery of the goods to the person's agent on instructions, you have completed, you have done the delivery part. Is it clear to all of you? Manan, where did you text me, dear? Like, where did you text me? Lien means what? To retain the possession of goods. Not my goods. My goods, so I will anyway retain. Retain the possession of the goods means someone else's, belonging to someone else. Okay? You have messaged me, then I think I've missed it. You please drop a text again. Please, just immediately, or now you don't do it. You do it, I will reach to my hotel only around 8ish. Do it, then I will come back to you. Okay? So chalo, moving back again. So when we talk about lien, lien can be of two types. Lien means to retain the possession, particular lien or general lien. Let us say I have rendered some service to you. I have rendered some service to you. If I have rendered some service to you, you should pay me for the service that I have rendered. You don't pay me for the service. Can I retain your goods? Let's say tailor has stitched the shirt. You don't pay him. Can he retain the goods? That is, can he retain the shirt unless you pay him? Yes. This is particular lien. That means I have rendered some services over the goods, and to get the charges of the services, I keep the goods with me. Unless you pay me the charge, I'll not give you the goods. Can I do that? Yes. What is so general lien is basically the bailee has rendered services exercising his labor and skill. He has a right to retain these goods until he receives remuneration for the service he has rendered. But guys, let's say I ask you to stitch three shirts, I pay you for one. Can you keep all the three? No, I paid you for one, you should hand me one. I have not paid you for two, you can keep the two. Right? Now, however, in the following cases, he cannot exercise his rights of lien. When? He did not complete his work within time. I told you to complete the work within time, you did not. Then what lien you are exercising? Or second, he himself allows the bailor to take the goods. Once the goods are gone, rights of lien is gone. For lien to be exercised, I should have the goods. I don't have the goods, how can I exercise? The next one is general lien. It is over the general balance of account. This lien is exercised over the general balance of account, and this is actually not given to everyone. Only banks or the CAs, only these people can do it. That means what? If let's say you have two FDs with the bank, and against one FD you have taken a loan. Still, unless you pay the loan, the bank can stop you from encashing the second FD also. So the lien is exercised over the general account balance. Okay? General lien is basically a right to retain the property for the general balance of the account. Now moving forward, finder of the goods. So tell me, what are the rights of the finder of the goods? We'll just do it from here. So I have to search for it. What are the rights of the finder of the goods? First of all, let's talk about the duties. If you see, the duties are the same as that of the what? As that of the the duties are the same as that of the what? Bailee. So see, he must take reasonable care of the goods, not to use the goods, not to mix the goods, try to find the owner. Let's talk about the rights here. First and foremost, does he have a right of lien? Yes. He has a right of lien for the expenses or reward. Can he claim a reward? Look, this is your phone. Yes, it's my phone. Give me money, I'll give you phone. Can you do that? No. But if the person has announced the reward, do you have a right over the reward? Yes. So if he has announced the reward and he doesn't pay you give you the reward, can you exercise a lien over the goods? Yes. So you have a right of lien for the what? Expenses as well as the reward. Second, you have a right, if you don't get the reward that he has given, you may also sue for the reward. That means you can retain the goods till he receives the award, or retain means lien. He can exercise a lien for the reward as well as he can exercise a lien for the expenses. Can he sue for the reward? Yes. Can he sue for the expenses? No. No. Please, he can sue for any specific award, but he cannot sue for expenses. Why? Because expenses is something that you have incurred on your own. No one asked you to incur it. It was your choice, you incurred. So you cannot ask me to pay for it. So he cannot exercise a lien for the, I'm so sorry, he cannot sue for the expenses incurred. Just 1 second. Huh? So I repeat again, can he exercise a lien for the expenses? Yes. Can he exercise a lien for the reward? Yes. Can he sue for the reward? Yes. Can he sue for the expenses? No. One more right. Please remember, he cannot appropriate the goods. That means you cannot use the goods in any way you want. You're not the owner. You cannot go and gift it to someone. You cannot appropriate the goods. Next, can he also sell the goods? Can the finder of the goods also sell the goods? Yes, the finder of the goods may also sell the goods. But if he wants to sell the goods first, the owner is not found after reasonable search, or the goods are perishable, or the owner is found but he refuses to give lawful charges. What is lawful charges? Every expense that I incurred for keeping the goods, for tracing the owner, whatever. And the lawful charges are two-thirds or more of the value of the goods. So please understand, the lawful charges are two-thirds or more of the value of the goods. Can I go and sell the goods? Yes. But if the lawful charges are less than two-thirds, okay, less than two-thirds of the value of goods, then in this case, can I sell? No. Can I exercise a lien? Yes. Can I sue? No. I hope it is clear to all of you. Yes. Now, when is the termination of bailment takes place? When the period is over, purpose is over. So don't write one line if you get in the exam. In the Swift scans, I've given a little explanation. Okay? You should at least explain it in 1 or 2 lines. Then when the bailee makes an unauthorized use of the goods, when the subject matter is over, when the parties are over, if it is a, that is, parties are over. And the last one, if it is a gratuitous bailment, it can be terminated at any time. I hope it is clear to all of you. Yes, with this bailment is over. I'm just giving you a minute. If you have any question to ask, you can. Otherwise, we'll move forward. I hope you're going through the questions of Swift scans. I said that's a different story these days. We look into the previous year questions hoping that we will get some repetitive questions. But nowadays the question are future questions. That's a different story altogether. But still solving questions gives you a little bit of a clarity on how to crack the questions. Whenever you're just solving the question, not writing it, just reading it, always your mind should be, don't write the full provision, because you cannot write every answer full provision. But let's say you have taken 10 questions of agency, one you write, two you write, the rest you're solving. Even when you're solving, you should be very careful that when you're solving, your mind should be like, okay, if I write this answer, I will write these provisions. That is how you should do it. So if I'm writing this answer, my provisions, this point will be my provision. You cannot write all the 10 questions if you have taken up for agency. I agree. But when you are solving also, it should not be like, acha, yes, no, no. If I write this answer, this will be the provision that I will write. When you keep doing this on a continuous basis for a period of time, in that case, what will happen is, that you will, what do you say, what I was talking about, you will get the hang of cracking the questions, the hang of what provisions have to be written for the answers. Please do practice this method, okay? Moving forward, contract of pledge. Pledge is what? Pledge is a bailment of goods. So in case of pledge, also it's bailment. What is it? It's a bailment of the goods as a security for a payment or for the performance of the. When I give human as a security, it's a guarantee. When I give things as a security, it's a pledge, right? It's a bailment of goods. So let's say D took a loan from C and he gave a jewelry worth 8 lakh to C. This jewelry is given as a security for a loan. This is pledge. It's a bailment. So the person who gives the goods is the bailor, and the person to whom the goods are given is the bailee, right? So similarly, the bailor is the pawner and the bailee is the pawnee, and all the rights and duties of the what of bailor and bailee will be the rights and duties here, correct or not? Yes. So rights we will discuss separately. Rights we will obviously, oh my god, where did I go? How did I go here? Hmm. So if you will see here, duties are the same only. Duty to take reasonable, duties of the pawnee, that is bailee. Take reasonable care not to make unauthorized use of the goods, right? To return the goods back once the debt is paid or the contract is performed, not to mix the goods with his own goods, not to do any act which is inconsistent with the terms of pledge, or to return any accretion to the goods. Same things we have already discussed in bailment. If you see duties of the pawner, that is bailor, the pawner is liable to pay the debts or perform the contract. Then he must compensate the pawnee for any extraordinary expenses incurred by him for preserving the goods pawned. Then it is he must disclose all the faults in the goods. If it occurs due to pawnee's defective title in pawner, the pawnee suffers any loss, he must indemnify for that loss. If the pawnee sells the goods due to default by the pawner must pay back the deficit. This we will discuss in a while. So you will see we have already discussed all of these points. What we need to discuss is rights of pawnee, okay, or rights of pawner. First, rights of pawnee, retainer, lien. If he does not get the money, can he exercise a lien? Yes. Now, listen very carefully. He can exercise a lien for principal amount, for interest amount, and for ordinary expenses. So that means the lien can be exercised not only for the debt amount but also for interest and expenses incurred. But please remember, you cannot exercise lien for extraordinary expenses. No. Ordinary expenses, yes. So let's say you gave me a piece of jewelry and you told me you keep it in the locker, I'll pay you. So that's the ordinary charges. Let's say one of the diamond of the necklace came out. So I took it to the jewelers to repair, and whatever the charges, that's extraordinary. I can sue you to recover that expense, but I cannot, and I repeat again, I cannot in any case retain the goods for this extraordinary expense. Okay? But in case of extraordinary expense, I can sue to recover them, but I have no right to retain the goods. So I cannot exercise any lien for extraordinary expense, but I can sue you for the extraordinary expense. Clear to all of you? Yes. Then the second part, right to retain for subsequent advances. What is this? Let us say I gave you piece of jewelry of 8 lakh for a loan of 10 lakh. Then C again gives a further loan of 5 lakhs. Can he exercise a lien over this jewelry for 5 lakhs also? Yes. Even though this jewelry was given for a loan of 10 lakh as a security, he can exercise a lien even for that 5 lakhs. So, see, right of retainer, where the pawnee lends money to the same pawner after the date of pledge, it is deemed that the right of retainer is not only for the main loan but also, that means you can exercise for even subsequent advances. That means later on he gives more loans without any security, it will be deemed that the jewelry will act as a security for the subsequent loans. When the pawner makes a default, let us say the pawner had to pay 9 lakh amount, 1 lakh interest. The jewelry was sold at 10 lakh. Same, no problem. The jewelry was sold at 12 lakh. This is a surplus. This is what? Surplus. Now, if the, first of all, please understand, before I explain this, let me explain something else here. If I don't get my money, can I also sell the goods? Yes. If you don't pay me on the due date, I can sell the goods. But before I sell the goods, I must give you a notice of sale. I must give you a notice of sale. Let's say amount plus interest comes to 10 lakh. And the goods are sold at 10 lakh, no problem. But let's say the goods are sold at 12 lakh. That means it is more than the amount to be paid. So that 2 lakh is surplus. Can the pawnee keep it? No, it does not belong to you. The pawnee must give it to the pawner. So if there is a surplus on the sale, he must hand it over to the pawner. But let us say it is sold at 9 lakh. 9 lakh I will keep. 1 lakh, for that 1 lakh, I can recover it from the pawner. That means I can sue him for that remaining 1 lakh. So see here, it was given, if you remember here, due to default, the pawner must, if the pawnee sells the goods due to default by the pawner must pay the deficit. If there is a deficit on sale, must pay the deficit. Always remember, Soumya, whoever is receiving has double E. Who is receiving the goods? Bailee. Who is receiving the goods? Pawnee. So always remember, whoever has double E is receiving, and whoever has OR is giving. Clear? So pawnee is giving or taking? Giving or taking? Taking. Pawner is giving. So always remember, D took a loan from C and D gave a jewelry to C. Who is receiving? So Soumya, you will tell me. Who is the bailor? Who is the bailee? Who is the pawner? Who is the pawnee? Done. But bata to do, C is the pawner or the pawnee? Bailor or the bailee? Please tell me that. Exactly, because C is receiving. Clear? Chalo, moving forward. Pledge by non-owners. Here, please, nemo that code non-habits. Just recall that. Guys, we are done Sale of Goods Act ka? Yes, yes. Correct. Yes. Have we done the revision of Sale of Goods Act, guys? Matlab, not the marathon, the detailed revision. We have done, no, Sale of Goods Act. We did not do, we did, no. We did for Sale of Goods or companies. Yeah, we did. You might not have attended PRADS then. We did it, yes. We did it. Companies we did not do. Partnership also, I had uploaded a video. Companies, I think, yes, we did it. Companies we did not do. Companies and I think negotiable, right? Next, should I do one writing session or first we should do companies? Companies is there. No, no. Did we do it? Did I do it for your batch? Chalo. Pledge by a mercantile agent. So who's a mercantile agent? Who is a mercantile agent? He can buy the goods. He can sell the goods. He can consign the goods. He can consign the goods for sale, or he can even pledge the goods. Okay. So he can. O gave his card to M to sell. M goes and pledges the card to P. Is the pledge valid? Okay, okay, I'll just plan accordingly. Is the pledge valid? O gave his card to M to pledge. M pledges the card to P. Is the pledge valid? Yes. The pledge is valid. When a mercantile agent acting in the ordinary course of the business, that means he's not a mercantile agent only for this contract, it's his job, has the possession of the goods or the document of title with the consent of the owner, and the pawnee acts in good faith. Pawnee believes that M has a right to pledge. This pledge is valid. Excuse me. Pledge by a person in possession under a voidable contract. S sold his goods to B, and B pays by a check, but he has no balance in his account. Fraud. B goes and pledges the goods to P. Is it valid? Yes. Before S cancels, if he pledges, it's valid. So where a person has the possession of the goods under a voidable contract. So please understand, the point is saying under a voidable contract. That means it is very important that you don't have the possession of, the contract is not cancelled. I'm so sorry. And before the contract is rescinded, that is cancelled, pledges is to the pawnee who acts in good faith. The pledge is valid. Right? The pledge is valid. Pledge when pawner has only a limited interest. So I found goods belonging to someone lying on the road. I spent 5,000 rupees to repair it. I have an interest of 5,000 in the goods. I can pledge these goods for 5,000. Pledge by a co-owner in possession. A, B, C jointly purchase the car. A has the car with B and C's consent. A goes and pledges the car to P. The pledge is valid. Where the goods are owned by many persons and with the consent of other owners, the goods are left in the possession of one. Such co-owner may make a valid pledge in his possession, and the pledge is valid. Pledge by a buyer in possession, seller in possession. A gave his goods to B on sale on approval. B pledges the goods to P. Valid. A sold his goods to B, but goods are still with A. A goes and pledges it to P. Valid. We already did it in Nemo dat quad non-habit. See, whenever you are reading a topic, questions are always good because they give you a little bit of a clarity on the topics. Also the provisions. It's good to solve questions. They will just give you clarity. You cannot write all of them. Just go and solve them. Pledge by seller or buyer in possession. A seller in whose possession the goods have been left after sale, or a buyer who with the consent of the seller obtains the possession of the goods before sale can make a valid pledge provided pawnee acts in good faith. Okay, with this we are done with this bailment and pledge. Let's go to agency. Just let's take 2 minutes. I'll just be back in 2 minutes and then we'll continue with agency. Okay, back to the so I hope you are back. Do read the differences. They do ask the differences sometimes. Okay. Moving on to the last one. Agency. Agency is huge. It's easy, but it's huge. So you have to be very careful when you are doing this topic because it's so huge. You shouldn't miss out on anything. What is agency? Basically, agent is a person who is employed to do any act for another or to represent another person in dealings with third person. So basically, when I appoint someone as my representative, or when I represent to do my act or to represent me, that person is called the agent. And the person for whom the work is done is the principal. Always remember, for the act of the agent, principal is liable. And you know what they say? They don't say contract, they say agency is an agreement. And since they say agency is an agreement, even a minor can become a what? Agent. So please understand, a minor, can he be an agent? Yes. But can a minor be a principal? No. Because if the minor is principal, then who will be liable? However, if the principal is minor, then in that case, the agent is personally liable. Okay? Then, in case of agency, consideration is not mandatory. If you remember Locha to no consideration, no contract, that we are done. We are done there. That in case of agency, consideration is not essential. Now, who can employ an agent? Only a person who is of majority, who is of sound mind, can employ an agent. Who can be an agent? Any person, even a minor can be an agent. Creation of agency. Agency can be created either by express agreement or by implied agreement. By express agreement is by words. By words, you appoint anyone. Generally, you make a power of attorney for the person and you appoint that other person. Fine. When we say implied, this is where we need to study. By estoppel, by operation of law, by emergency, right? Wife as an agent, and by ratification. So these are the 5 agencies. The first one is estoppel. In your book, holding out is not given, so I'll not teach you that. Okay? By estoppel. What is by estoppel? X tells Z that Y is my agent and Y does not deny. So when he does not deny, he becomes an agent. So this is agency by estoppel. When a person represents another person as his agent, even though he is not the agent, and such other person does not deny it. This is agency by what? Estoppel. In this, there are a few things that has to be kept in mind. There must be a representation. First, you have to write in your answer all these points if you get on estoppel. There must be a representation. Second, representation may be express or what? Implied. There must be a representation. Representation may be what? Express or implied. Just one second. Huh? there must be a representation. The representation may be express or implied. Then representation must state that agent has authority to do the work. Fourth, the third party relies on the representation. Fifth, having relied, the third party makes a contract. Right? So you have to, whenever you get a agency on by estoppel, all these points have to be there in your answer. I hope it's clear to all of you. Yes? This is agency by estoppel. Now, what is agency by necessity? What is agency by necessity? So, there are two cases. When the agent exceeds his authority in an emergency, or a person was given the property of another to take care, and to protect the property, he has to do something which is not within his authority. To protect the property, he has to do something which is not within his authority. That is known as what? Agency by authority, agency by necessity. However, there has to be a real necessity. The person must not be in a position to communicate, and he must have acted as a man of ordinary prudence. Okay? When all of these three conditions are fulfilled, we can say agency by necessity is valid. Operation of law, there is nothing to explain here. There is nothing to explain here, only partnership. In case of partnership, the partners are the agents of each other by the operation of law. Okay? Wife as an agent. Can the wife, so let's just do a sum up of all of this. Can the wife use the credit of her husband? Yes. She is the agent of her husband for necessaries. Necessaries depends on the status of the life. If they are living separately due to the wife's fault, she is not the agent. If they are living separately and he pays her maintenance expenses, she is not the agent. So see here, she is the agent of her husband for necessaries. Necessaries depends upon the status of the life. If they are living separately due to no fault of the wife, she will be the agent. If they are living separately due to no fault of the wife and the husband pays her maintenance expenses, right, she will not be the agent because she's already getting maintenance expenses. If they live separately due to wife's fault or choice, she cannot use the credit of the husband. That means she's not the agent. However, if the husband has clearly told the third parties that don't give anything to my wife on credit, or the goods purchased are not necessaries, or he has given enough money for her to purchase and the third party knows about that, or the tradesman was expressly told not to give credit to the wife. That means he has told the third party, don't give her credit. The third party knows she has been given enough money, or the goods are not necessaries, then she cannot use the credit. In all of these cases, she is not the agent of her husband. And when I say not the agent of the husband, it means the husband shall not be liable for the acts of the wife in the following cases. I hope it's clear to all of you. Agency by ratification, there are two cases where agency by ratification occurs. I told my agent to get a loan of 1 lakh. He got a loan of 1.2 lakhs. He exceeds his authority. If I accept, I am liable. If I don't accept, I am only liable for the authority given. Or you are not my agent, but you go and act on my behalf as if you are my agent. This is what? Pretended agent and pretended principal. If a principal accepts, he is liable, otherwise he is not liable. Now, for ratification, a few things has to be present. Ratification must, okay, these points now you will not find it in the book, so you can skip it. It must be done with the knowledge of all material facts. It must be done within a reasonable time. It must be communicated to the other party. Only lawful acts can be ratified. Only the contract can be ratified as a whole. A part cannot be ratified. One last point. 2 points, sorry. Ratification can be done only on disclosure of all material facts, and ratification must not put the third party at a loss. What does this mean? That must not put a third party at a loss. A gave his goods to B on condition that it can be terminated at any time by notice. That means A can give a notice at any time and terminate the the goods. A gave his goods to B to use. Anytime A can give a notice and stop the use and take the goods back. C gave a notice to B without A's authority. Gave a notice of termination to B without A's authority. It's not valid. Now he goes to A and says, please ratify my act. Now if the act is ratified, it will put B at a loss. So this is not valid. It cannot be ratified. But ma'am, anyway, A can give a notice anytime, and yes, he can. But if C asks A and then gives a notice, then it's valid. But he's already done the act and wants to ratify. That is not valid, because then it will put B at a loss. I hope it's clear to all of you. Anyone has any doubts in any of the cases? Okay, now sub-agent and substituted agent. I'll just sum up this whole thing. When P appoints A as his agent and A appoints S as his agent, it is sub-agent. Can you appoint a sub-agent? No. Delegatus non potest delegare. What has been delegated cannot be delegated again. What has been delegated cannot be delegated again. So on this grounds, A cannot appoint S. So what is a sub-agent? Who is appointed by the agent under the authority of the agent. Appointed by the agent under the authority. So he is actually the agent's agent. He is actually what? The agent's agent. Question is, can you appoint a sub-agent? No. If the sub-agent is appointed, who is liable for the act of the sub-agent? Agent. To the third party, agent. However, I ask this principal, can I appoint a sub-agent? He allows. Or the agreement states that a sub-agent can be appointed. Or the business is such that it is the custom to appoint a sub-agent. Then in all of these cases, can I appoint a sub-agent? Yes. Here the sub-agent is properly appointed. And when the sub-agent is properly appointed, then in that case, the principal is liable to the third parties for the acts of the agent. But the agent will be liable to the principal for all the acts. So basically, let's say I ask you, please keep my laptop in the office. You go and tell your friend, please keep the laptop. While she's taking, the laptop falls. You are liable to compensate me. While she is taking the laptop, the laptop falls in someone's iPad. That iPad is destroyed. I never asked you to appoint her. You are liable to the person, owner of the iPad. But you told me, ma'am, I cannot walk. Is it okay if my friend takes it? I'm like, yeah, okay. Then I am liable to the owner of the iPad. But I can recover the damage from you. I hope it's clear. So see, where the agent is not properly appointed, the agent shall be liable for the acts of the sub-agent to the principal as well as to the third party. The principal is not responsible. You can appoint a sub-agent in the following cases. If it is as per the terms of the agreement, or some emergency arises, or it is the custom of the trade. When the sub-agent is appointed properly to the third party, the principal is liable. The agent shall be liable to the principal. The sub-agent is responsible for his acts to the agent and not to the principal. But if the sub-agent commits a tort, then he is liable to the principal. Substituted agent. P appoints A as his agent, and for some other work, another agent S is appointed. P asks A that you please, for this business, please appoint another agent. So he is appointed by the agent, but he is working under the authority of the principal. He is appointed by the agent, but he is working under the authority of the principal. It's a substituted agent. He is appointed by the agent, but to act for the principal. Right? Now, who is liable for the act of the substituted agent? Obviously, principal. He is principal's agent. But if the co-agent was negligent, he was negligent, then in that case, agent will be liable to the principal. You did not appoint, you knew the person's reputation was bad, but still you appointed him without making a proper check. Is it clear to all of you? Yes, moving on. This liability to third party, I'll do it with a different note. You all take a picture and remember that. That we will do, okay? Now moving forward. These are easy topics, but you can get a lot of question from these topics. So we really need to be very careful also. Oh my God. What the hell? Just 1 second, guys. Okay, duty and obligations. First, duty to follow the instructions or custom. If the principal has given any specific instructions to the agent, he must follow. If no such instruction is given, but it is assumed from the conduct of the business, he must follow. If he fails to follow the instructions and the principal suffers damages, he must compensate the principal for those damages. Right? So I repeat again, he must follow the directions given, and if there is no directions given, he must follow as per the custom. If he does not follow and any loss is sustained by the principal, he must indemnify him. It is his duty to take reasonable care and skill, that a man of ordinary prudence, while doing the business, whatever he would do, same way he must take care of the business. And if he does not take care and the principal suffers any damage, then he must compensate the principal for that. He is bound to act with reasonable diligence and to make compensation to his principal in respect of consequences of his neglect of skill or misconduct. Whenever the principal asks for the accounts, he must render. Accounts does not only means the books, it includes the vouchers also. So whatever entries are made, there would be vouchers included here. Then whenever he is not able to understand how to do the work in a given situation, he must communicate with the principal to seek his instruction as to how to do the work. He must not deal in his own account. You go to the land, you see a mine is there, and you realize the value of the land is much high. You don't tell the principal, you buy the land on your own. Right? If you deal in your own account, the principal, when he comes to know, he can cancel. So you purchase the property at 50 lakhs. You know the value of the property is minimum 80 or 90 lakhs, but you purchase it for 50 lakh without telling the principal you are purchasing it. It's your duty to give him the the principal can cancel the contract. Now you sold this land to someone at 80 lakhs, making a profit of 30 lakhs. the principal can claim this 30 lakhs also. Now, when the goods are sold to someone else, he cannot cancel the contract, but he can claim the age from the agent any benefit which has resulted to him from the transaction. Okay? Duty not to make secret profit. Secret profit means over and above his remuneration if he earns anything. Let's say A gave his land to B to sell it for 20 lakhs. He sold it for 30 lakhs, pocketed 10 lakh, gave 20 lakh. He has no right to keep that 10 lakh. He must give it. And if he does not, the principal has a right to take it. So he must not make any secret profits. And if he does, he has to give it back. Duty not to delegate. That means not to appoint a sub-agent. Because it's based on trust, no, you cannot appoint a sub-agent. If you have received any money on behalf of the principal after making the deductions, right? Deductions can be for your commission, advance, that is remuneration, advance and disbursements. So deductions can be for your remuneration or disbursements. After doing that, whatever is left, you should hand it over to the principal. And if you have come across any confidential information while doing the business of the principal, you cannot use it against the, you should not use the information against the principal. Okay? It's more of common sense than anything else. It's more of common sense. Remember the keywords, make sure you write the keywords, that's it. Rights of an agent. Can he retain out of the sums received on principal's account? Let's say principal gave him 10 lakh ka goods and he gave the principal 2 lakhs advance. Can he deduct the 2 lakh from this 10 lakhs? Yes. He sold the goods. Can he deduct the 2 lakhs? Yes. Then his commission was 1 lakh. Can he deduct this also? Yes. To sell the goods, the principal told him you can spend up to 30,000. He spent 20,000. Can he deduct this also? Yes. So the agent can deduct. The agent can deduct all money due to him in respect of advances, in respect of expenses and remuneration payable to him. All these three he can deduct. Then he has a right to remuneration. For the work that he has done, he has a right to get remuneration. If he has misconducted in his work, he will not be paid remuneration for that. But for the rest of the part, he will be paid remuneration. He will be paid remuneration as agreed, and if nothing is agreed, as per the custom. However, if he is guilty of misconduct, he is not entitled to any remuneration for that part. So let's say I gave you 10,000 to invest in good stock. You invested 9,000 in good stock, 1,000 is in bad stock. For that 9,000, I have to pay you the remuneration. For that 1,000, I may not pay you. Agent's lien on principal's property. Again, lien we have already discussed. I have a right to receive the amount due, commissions, disbursements, and whatever services I've rendered. I have to be paid for that. If you don't pay me, I have a right of lien over your property. I have a right of lien over your property. But you know what? These rights are available only for those money that I am lawfully entitled to receive. For example, the agent was told that you can spend up to 30,000 to sell the goods. He spent 50,000. Principal paid him 30. He said, I will not pay you 20. I told you don't. He goes and exercises a lien. Can he exercise? No, because he's not lawfully entitled to that money. Right? And he must have the property which belongs to the principal, and he has received it in the capacity of his agent and during the course of business. What does this mean? Let's say he gave me 1,000 kgs of goods to sell. I sold 600, 400 left. He did not pay me. I exercise a lien over the 400. Can I do that? Yes. Because I've received it. It's the principal's property and I've received it in the ordinary course of the business. Fine. I sold the entire 1,000 kgs. Now I did not get the money. I'm like, wait, I'll not leave you. I go to his house and I take his keys, car keys, and go away. Can I do that? No, because the property was not received in the course of business of agency. Okay? Then next, however, the lien is lost when the I don't have the property at all, the agent only says, okay, okay, whenever you want you take your money, I will not, whenever you want you give money, I will not keep your goods. You're waived off. Let's say, for example, the principal was supposed to pay you the commission today. He comes to you and says, I'm not in a position to pay today, can I pay you after 20 days? Now if he would not have paid you today you would have a right of lien over the property. He says, can I pay you after 20 days? You say, yeah, yeah, no problem. Pay me after 20 days. Can I say for the 20 days you have waived off your right? Yes. So when the agent gives up his right or the right of lien, agent's lien is subject to a contract to the contrary. That means it is as per the terms of the contract, he has no right to exercise a lien. Now, right to be indemnified. Indemnified means what? To make good or pay back. Whatever lawful acts I have done in the ordinary course of the business, if I suffer any loss, you have to pay me. Let's say A tells B, please sell my goods on my behalf. B contracts to sell it to C. A gave his goods to B to sell it on his behalf. B sells it to C. A asks B to sell his goods to someone. B sells it to C. A does not send the goods to B, so B cannot give the goods to C. C sues B for damages. Can B recover the damages from A? Yes. Because of my lawful acts, if I have suffered any damage, I should be indemnified from the agent. Right of indemnification against acts done in good faith. A stole the goods and gave it to B to sell. B sold it to C, not knowing the goods are stolen. When C comes to know, C claims the price from B and damages. Can B claim the price and damages from A? Yes. If the agent acting in ordinary course and in good faith does any work and suffers any damage, he can recover the damage. Non-liability of employer of agent to do a criminal act. If you have done any criminal act, even on my authority, I am not liable. I am only liable for lawful acts. A says to B, go and hit C. B goes and hits C. C files a case against B for damages. Can B recover the damages from A? No. Why no? Because this is not a lawful act and I am only liable for a lawful act. The next one, right to compensation for injury caused by principals. Because principal was negligent, the agent suffers damages. Let's say the principal has to build a staircase to reach the top of the tree and the agent will go and pluck the fruits from the tree. The agent was like relying on the principal. The principal did not make the staircase properly, the ladder, sorry, not the staircase, I'm so sorry. He did not make the ladder properly. When the agent was going up, he fell because the ladder broke. Can he claim the damages? Yes. Due to principal's neglect or want of skill, if the agent has suffered any injury, he can claim the expenses from the principal. With this, we are done with rights. Is it clear to all of you? Agency is huge. They ask a question. Every time they ask one question from agency, it's huge. Can we go from to the next one? Yes. Principal's liability to third parties. That means for the acts of the agent, what is the liability of the principal? If in the ordinary course of the business, if the principal has done anything to do the business of the if the agent has done anything for the principal's business, the principal is liable. Okay? He is liable. Let's say A tells B, go and recover my money from C. B takes a legal action, files a case against C. So isn't A liable for that? Yes, because it's a lawful act. Then second, principal's liability when agent exceeds his authority. See here, first, principal is not liable. Principal is not liable if the agent exceeds his authority. Okay? Now, if the authorized and the unauthorized parts can be separated, principal is liable for the authorized part but not liable for the unauthorized part. If both the parts can be separated, then in that case he will be liable for the work authorized, and what he does beyond the scope of his authority, he will not be liable. So he is only liable for what is within his authority. If both the parts cannot be separated, principal is not bound. So please understand, when it exceeds his authority, remember, not liable. If parts are separable, then liable for what? When the parts are not separable, not liable. Simple. Now see, when an agent does any work without the authority, but the principal has by his words or conduct made the third party believe that the agent has the authority to do the work, obviously principal is liable. Agent is doing the work which is not within his authority, but the principal has made the third party believe either by his words or by actions that the agent has the authority to do the work, obviously principal is liable. Clear? If any notice is given to the agent in the ordinary course of the business, as between the principal and third party, it acts as if it's an agent to the principal. A purchases goods on behalf of P from B. B told A, the goods are not mine. So when the notice was given to A, it is deemed that the notice is given to P. So see, if it is obtained in the ordinary course of the business, as between the principal and the third party, it will have the same legal consequence as if it was given or obtained by the principal. That means knowledge of agent is treated as knowledge of principal. Okay? Then principal's liability for agent's fraud. If agent has committed a fraud, principal nahi, agent, as between the principal and third party, the contract is voidable. Even if he did not, so has committed a fraud but so by such agent, as if the misrepresentation or fraud is committed by the principal. That means the contract is voidable against the principal. It will be deemed as if the principal has committed the fraud. Is it clear to all of you? Now here I want to discuss this one thing. Now see, rights of the third party. Undisclosed agent. When the agent contracts with another person and that other person does not even know, or he has no reasons to believe that the person he is contracting with is just an agent, then such third party, as against the principal, he will have the same rights as he would have had against the agent. That means against the agent he could enforce the contract. Similarly, against the principal also he can enforce the contract. Okay? Now, if the third party did not know that the person was the agent, and before the contract was even done, he comes to know who is the principal, and he is a person who he does not want to deal with, then he can cancel the contract before the performance. That means what? You make a contract with me, but you don't tell me that you are an agent. Now, before the contract is performed, I come to know who is the principal, or I come to know you are just an agent, and I don't want to make a contract with an agent. I thought the contract is with you. So I can actually cancel the contract. What I can do? I can actually cancel the contract. Okay? Then, second, performance of a contract where agent is supposed to be the principal. That means what? the agent makes a contract with the third. So this was from the angle of the third party. This is from the angle of the principal. When the agent makes a contract with a third party without telling him that he is just an agent, then in that case the principal can enforce the contract just in the same way as the agent could have. That means what? Depending on the terms of the contract, whatever were the terms, subject to that, the principal can enforce the contract. Third, if the contract is made where the contract is like where the agent is personally liable, in that case the principal can the third party can sue either the principal or the agent, anyone. And the fourth case here, if the contract is made very clearly that I will only sue the agent, not the principal, or I will only sue the principal, not the agent, then you cannot sue the other party. This thing, please guys, I would suggest, I will just show it to you. I would suggest you please take a picture of the whole thing. Okay? Like I'm just showing it to you. You just take a screenshot of it later, now, whenever. Okay? That's it. Now, personal liability of an agent. When is the agent personally liable? When the contract specifically says, or the principal resides outside India, or I don't disclose that I'm acting for someone else, that is, I act in my own name, or the principal is a person who cannot be sued in the court of law. Okay? Or the agent signs the contract in his own name, that is, he does not say I'm an agent, he signs it in his own name. A principal who does not exist, or where the agent acts outside his authority. If the principal accepts, principal is liable, otherwise the agent is liable. When the principal is a minor or has no capacity to contract, or in case of pretended agent, that is ratification, second case. If the principal accepts, he is liable, otherwise the agent is liable. Now, when does the agency come to an end? By an agreement, revocation of authority by the principal or by the agent by giving a notice, when the agent is appointed for a particular object and the object is attained, or when the agent is appointed for a time and the time is over, death or insanity of the principal or agent, insolvency of the principal, the subject matter is destroyed, principal becomes an alien enemy. I'm acting as an agent for a person who resides outside India, and now we are in enemies. Or when the principal or an agent is a company and the company is dissolved. What is irrevocable agency? When the agency is coupled with interest. What is agency coupled with interest? When a agent has a personal interest in the agency, and because of that interest the agency is created. This is an agency coupled with interest. And in case of agency coupled with interest, this agency cannot be terminated. Just one last thing, effect of termination. When I terminate my agent from his agency, I give him a notice today, but he receives the notice after 10 days. As far as he is concerned, termination takes place after 10 days. So for him, termination takes place only when he receives the notice. And if he does any act during this period, the principal is liable. So guys, with this, we are done with this Indian Contract Act. Oh my God, finally, oh my God. Tomorrow, what do you want me to do? So tell me tomorrow, what do you want me to do? What should we do tomorrow? So I guess you're not even able to understand Companies Act. Okay. Either I'll do writing session, one writing session I'll do for Indian Contract Act. I'll pick up some 5 7 tough questions, and we'll do Companies Act tomorrow. Maybe I'll do Companies Act only. In that case, 2 days Companies Act, or one day Company Act. We'll finish it off in one day, I guess. We'll try and see, and then I'll do the writing session. Okay. So I'll update you all tomorrow morning what we are doing. I'll send you the link. Till then, till tomorrow, happy learning, stay motivated. Bye bye, guys. Take care. Good night.